Let's explore the fine difference between various jargons that are used in constitutional discourse. Let us consider the first one, the Constitution of India. The Constitution of India is a specific legal document drafted and adopted by the Constituent Assembly in 1949. As mentioned earlier, this entered into force on 26 January 1950 and continues to govern us as the supreme law. The Constitution lays down the framework for holistic governance of our country. It is regarded as a transformative document that empowers its citizens for an egalitarian future and lays down responsibilities and basic policy guidelines for the state. The Constitution of India is also sometimes referred to as the Indian Constitution. Another term that is often used in constitutional discourses is constitutional law. Constitutional law is a broad term and refers to the branch of law dealing with the Constitution. Within its ambit falls various decisions of constitutional courts, legislative acts, international treaties, and even conventions in a country like Britain. In India, we have a written constitution. Constitutional law is largely codified, supplemented by judicial decisions. Finally, constitutionalism. Constitutionalism is a school of legal thought that postulates governance by a constitution. It argues for limited and accountable government.